If for a fact the court is persuaded that the alleged offences took place in Naivasha, but the court nonetheless wishes to assume jurisdiction, Your Honor, I humbly then submit on behalf of the accused persons and for the defense that before even my colleague addresses Your Honor on the issue of bail bond for the accused persons, that you indeed make a ruling as to whether you even have jurisdiction, Your Honor, to further entertain this matter. I humbly submit.
Your Honor, additionally, the second accused is 93 years old. He is presently out on bond, bail, in relation to the file that has been closed. We fought to get him out on bail, out of heartlessness of the police in this country. Retain the bail terms, Your Honor, to safeguard his liberty and freedom, even as you determine the question of jurisdiction. Your Honor, this morning, they came to this place by themselves. It means they will comply, and with superior advantage, they do have 3 lawyers, officers of this court. We take maximum responsibility for their presence to this court. Indeed, the first accused is before you in a related matter pertaining this land in Dabibi, which is a contentious issue in this country. Admit him also on the same bond terms that he has been out on and upon which he came to court today. You know, lastly, let's stop the madness going on in this country. At some point, it has to stop. We lawyers and you judicial officers have to be courageous enough to protect the madness going on in the lands department in this country. We are fighting over land and politics. Is this court going to be dragged into the arena of politics? No, you have no such powers. You only have the law on your side, and we have the facts and the law on our side. This gentleman's house was broken into by the same police officers over here. We'll go down for them anyway. But for now, just admit them to bail if you're minded to make any other ruling, even as you direct us further. They've been safe enough. The charges are similar. They have been unified into one. In fact, lessen their bail, reduce it considerably to enable them move forward. That's all.
And maybe, Your Honor, before you pen off, I would request you, kind self, that in the event, and is the most likely event that you find that you don't have jurisdiction in this matter, Your Honor, you can revert to status quo ante. Your Honor, because I appreciate that there are some boards which have been pressed, and the court may find itself in a scenario where it doesn't understand whether to go ahead or to go back when the issue of jurisdiction is raised. But possibly you can revert to status quo ante, and the accused persons, Your Honor, the court will know the terms to issue and the ruling that the court will make. That's for Your Honor.
Thanks so much.
Your Honor, the objection that was raised on jurisdiction is on the Criminal Procedure Code, Section 71. Your Honor, this is a magistrate court. And it can only be guided by the Magistrate Courts Act. Your Honor, at Section 2 of the Magistrate Courts Act, all magistrate courts have jurisdiction throughout the country. Your Honor, if a matter took place in Naivasha and the accused persons are brought before you, this is within Kenya, Your Honor. This is a magistrate court. So from section 2 of the Magistrate Courts Act, Your Honor, you have requisite jurisdiction to hear this matter and determine the same. Your Honor, and in interpreting the law, Your Honor, if there are two acts that are conflicting or appear to conflict, let's say in this matter, between the CPC and the MCA, then which one takes effect? The latter act is deemed to have repealed the previous act, Your Honor. Between the CPC and the MCA, Your Honor, it is the CPC that is first in time. So the Magistrate Courts Act is deemed to have repealed the provisions of Section 71 of the CPC, which talks about geographical jurisdiction of magistrate courts. So in essence, Your Honor, you have the jurisdiction. There is no forum shopping in this case, Your Honor. This matter is properly before this court because you have jurisdiction to hear matters throughout the country. On bond terms, Your Honor, the DPP has no objection. The parties are released on bond. But it is our kind submission that the bond terms should resonate with the offenses that the two are facing, Your Honor. That will be our kind submission, Your Honor.
Yes, Your Honor, I have something to respond to my learned colleague for the state. And Your Honor, I start by saying that I'm deeply troubled by the submissions of counsel and off record. The office of the DPP, Your Honor, ought to be an independent office. Allow me now to address you on the law. There is no conflict, Your Honor. I address you to Section 6 of the Magistrates Court Act. I read it to you, Your Honor, verbatim, and I know these are sections you're aware of. Criminal jurisdiction of a magistrate court. A magistrate court shall have and exercise such jurisdiction and powers in proceedings of a criminal nature as may be conferred on it by the Criminal Procedure Code, Cap 75. So, the magistrate court, in terms of jurisdiction, it must rely and borrow and conform with Section 71 of the Criminal Procedure Code. It further goes to say any other written law. But Your Honor, if we address ourselves to the reality of a criminal trial, why does the law insist that the trial must take place within the local limits where it was committed? For obvious reasons. One is the convenience of the accused persons because they are innocent until found guilty. So they should not be punished in the course of trial. Your Honor, the accused persons have already been convicted. They are suffering economically. They must raise resources to travel from their homes all the way to Nakuru. Number two, for the convenience of witnesses. Your Honor, you realize the nature of this matter is that so many witnesses are police officers. So at any given time, they will be out of their station. For how long? Should they also suffer because an offense is being tried outside the local limits of where the offense was committed? And lastly, is for some uniformity. Why should we try even a murder suspect who killed in Naivasha, and then we want to bring these men all the way from Naivasha to start trial in Nakuru? Your Honor, this is an injustice on the face of it, and a terrible injustice to people the age of the second accused, even the first accused. It should not even happen to someone who is not incapacitated, even a child. So, Your Honor, we solidly maintain that this court is not clothed with the jurisdiction. And we plead with your kind self to revert to status ante. That's all, Your Honor. Maybe my colleague may tip the scale. Something.
Perhaps one more point to add. That Your Honor, assuming that we did not persuade you on another front, but we would then ask, has the prosecution proffered any reason as to why the accused can't be tried in Naivasha, where the alleged offenses took place, and that they have to be brought here? Any compelling reason? Say for to say the magistrate court is clothed with jurisdiction to try criminal matters? It's the same question we would be asking. Would they, for example, if they feel at some point that it's necessary to take the accused persons and try them somewhere, say in Lodwar, because anyway, the court in Lodwar being a magistrate court there, it would be proper to take them there?
Your Honor, maybe I will object to that. I have already replied the application. It's raising new issues, which I don't know whether I am going to respond to them again. You should limit yourself on what I answered, Your Honor.
I've just said that no reason has been advanced. That's all I'm saying. No reason has been advanced as to why the trial must take place in Nakuru and not in Naivasha. All we are hearing are the court has jurisdiction. Your Honor, you should not then be persuaded by that line. In my view, it's horribly weak. And the court must then find, humbly so, that it lacks jurisdiction. Humbly submit.
The second accused is 66 years old. Consider that when you do the first accused is 66, the second is 9. Kindly consider the age as you make the trial and defendant.
Your Honor, maybe just to correct, I had talked of magistrate court.
Your Honor, to make us respect, my learned colleague has no right of audience because she's already exhausted her chance in law. She's already exhausted her chance.
I just wanted to correct you.
And in fact, Your Honor, if she was to be sincere, she also acted ultra bias by also approving the charge sheet, which is outside her jurisdiction. So let's respect jurisdiction and the law, Your Honor. That's all.
Then lastly, the charge sheet that has been supplied to us, Your Honor, has no case number, has no OB number, has nothing. Kindly, that is caution. If they are that guilty, they ought to have disclosed that before supply, and they cannot amend it now. We proceeded on a defective charge sheet. Let it be quashed instantly.
Yes.
Yes, sure. You're not, I travel from far because I'm actually doing the matter pro bono. Maybe I'll seek to inquire which day of the week is that? It's a Monday. Do you sit on Fridays? Because there's a high possibility that it will conflict with my maybe you can do a Friday. I don't know whether my land friends will charge me.
That's okay.
But definitely being the senior, I can buy you lunch, I can compromise you.
We have no trouble.
You know, maybe a Friday. Most of them. Most of them. Most of
It's
them.
convenient.
Most of like you are. You want to have a good afternoon.